1 minute? Okay. Oh, can you hear me? Yeah, okay. Yeah, okay. Ready? Okay. Good afternoon, everyone. If you can all take a seat, we'll start the program. Good afternoon and welcome to the annual Law Library of Congress Constitution Day lecture. I'm Aslihan Bulut and I serve as the Law Librarian of Congress. Each year we celebrate Constitution Day with a lecture, panel discussion, or an interview by a distinguished legal scholar. Constitution Day, which is officially known as Constitution Day and Citizenship Day, is a federal commemoration observed each year to mark the signing of the U.S. Constitution on September 17, 1787, and to recognize all who, by coming of age or by naturalization, have become citizens. This year, we are honored to have two distinguished legal scholars with us, Professor Robert Post and Dean William Treanor. Robert Post is Sterling Professor of Law at Yale Law School. He served as the school's 16th dean from 2009 until 2017. Professor Post specializes in constitutional law with a particular emphasis on the First Amendment. Dean Treanor is the Executive Vice President of Georgetown University and Dean of the Law Center, and he holds the Law Center's Paul Regis Dean Leadership Chair. Dean Treanor's areas of academic expertise include constitutional law, property law, criminal law, intellectual property, and legal history. Dean Treanor will interview Professor Post about his book on the Taft era United States Supreme Court, which is titled The Taft Court, Making Law for a Divided Nation, 1921 to 1930. This book was funded by the Holmes Devise, a gift funded by the late Justice Oliver Wendell Holmes, which established the U.S. Permanent Committee for the Oliver Wendell Holmes Devise, which includes the Librarian of Congress, to support the work of documenting and disseminating the history of the United States Supreme Court. Professor Post will take questions from the audience at the end of the interview. And with that, I am pleased to turn the floor over to Dean Treanor and Professor Post.
Robert?
Oh,
I'm inspired by Kamala Harris.
Bump.
So this is such a privilege. We're really delighted. I'm delighted to be here for Constitution Day, and I have been a fan of Robert Post's as long as I've been reading legal scholarship. And so this is just an extraordinary occasion. What I'd like to do is we're going to be talking about this book, which is really a tour de force.
This book.
That's remarkable. One thing I do want to talk about in a couple of minutes is, this is September 11th, a day that, is on all of our minds, and it's a day of crisis. And I think it's also very appropriate that this is a moment in which we're reaffirming the Constitution and what it means for all of us and its values at a time in which we think about the United States under attack. And one of the things that I really found so profound about your book is, it's unlike other books in the Holmes Devise series in that it really is truly a work of history, not just a work of law. And it's really grounded in context. And it's grounded in a time in which a divided Supreme Court is confronting a nation in crisis. So I want to focus on that. But before we get to that, the Holmes Devised series. What's that?
So when Oliver Wendell Holmes died, he left his estate. Well, first of all, I want to say what a pleasure it is to be in conversation with you, Bill. Bill is one of the great scholars and great leaders in American legal education, a legend, really. And it's an honor and it's really just a joy to be with you here today. And so to the Holmes Devised, when Holmes, who was the best legal mind probably that America has ever produced, when he died, he had no family. And in this shocking move, he left his estate to the federal government, who, of course, they know how to take your money and taxes, but they'd never gotten a gift like this, so they didn't know what to do with it. And they sat on it, and they cogitated, and they thought, and finally they decided that the best way to honor Holmes would be to fund a history of the Supreme Court of the United States. So it's more or less official. I report to an editor of the series who is appointed by the President of the United States, Maeva Marcus, who's here, who was the editor when I was writing this, and before her, Stanley Katz. And so when you write a book like this, you sort of have the obligation of writing. It's not actually official, but it feels official. You have a kind of burden that's put on you. It has to be the book of record, is basically the way you feel about it. And this history has had an extremely troubled past. It was given to a lot of law professors. They sat on it. They didn't write it. The particular book that I had, which is the Taft Court, this was originally given to Alexander Bickel, who was a famous law professor in the 1950s. And he didn't finish it, and he died. And then it was given to Robert Cover, who's a famous law professor, was my teacher, and he didn't finish it, and he died. And then they asked me to do it, and I doubled my life insurance and said yes. And that was 35 years ago.
Wow.
35 years working on this thing.
So, and it really is, when I was in graduate school, every constitutional historian was fixated on the Holmes Devised series and its troubled past. So Paul Freund, for example, was the first general editor, and I was talking to Maeva Marcus about this before. So he was the great constitutional law professor of his day, and President Kennedy asked him to be Solicitor General, and Paul Freund said, "I can't. I'm writing the Hughes book and the Holmes Devised series." And President Kennedy said, "So you'd rather write history than make history?" And as it turned out, he did neither, because he never finished the Holmes Hughes book. But it worked out because President Kennedy picked Archibald Cox to be Solicitor General, which really made it possible for him to be special prosecutor. So in some ways, the Holmes Devised series is a proof of God's existence. So
mysterious ways.
That's right, and I think Holmes would be very upset if anything concerning Holmes was taken as a proof of God's existence. Yeah. So you're assigned the book, and it's really, I really want to recommend it to everyone. It's a tour de force. It really is an amazing book. So talk about I, as you heard, I do constitutional history, but I focus on the founding. So basically, there are 4 volumes of the debates, the constitutional debates that we all look at. What did you have to work on in order to write this book? What are the primary sources?
Okay, so I'm asked to write a history of the Taft Court, 1921 to 1930. I don't know how many lawyers or law students there are in the room, but the challenge is to name 10 cases decided by the court between 1921 and 1930. I've never lost this bet because it's really hard to think about it. I really thought I had drawn the short straw. It was a very strange time, and half the book is trying to figure out why it was so strange and why it's been so lost to memory. So if you get an assignment of writing on the Supreme Court, the first thing you have to do is, of course, you have to read all the cases. So, you read the U.S. reports from soup to nuts, which is never an easy thing to do. And then you have to read all of the biographies of all of the justices and see what they were doing. And then you have to read all of their letters and publications. Taft himself who dominated on this court, has more than 600,000 letters in this building, he began to creep into my style. It was like possession by a very big fat man, and you couldn't write your own voice anymore, So you really have to get into the heads, and then you can begin to take the cases and begin to write about the cultural dynamics of the cases. I did get one source which was very unusual. I was, the court cooperates in this history because it's like an official history. So I was with Gail Galloway, who was the archivist at the Supreme Court, and we were rummaging around in the attic. The Supreme Court has an attic. And we came across a trunk, which was locked. But this is this old, dusty attic, and no one had the key. The archivist didn't have the key. So I remember we called a locksmith, said, can you come and unlock it? And there were all kinds of treasures, and some of them even had to do with the 20s. But the biggest treasure was that there were, 10, 11 leather-bound locked books. And again, didn't have the key. We had to call a locksmith to open them up. And they turned out to be the docket books of Justice Butler for 3 terms and Justice Stone for the whole period that I'm writing about, the whole from 1925 to 1930. So a docket book is a book that each justice has, and in it they record the votes at conference. So, the court hears arguments, and they go into this super top secret security room where they discuss the cases and they take their preliminary votes. And no one is supposed to ever know what they do in there. If you clerk, your justice might tell you, we had this argument, but that is the sanctum sanctorum in terms of preserving secrecy. You just never do it. And here I had the recorded notes and the recorded votes for, I would say, more than half, about 1,200 cases in my period. And this gave me a source of information that is inimitable. We had never had the ability to do that before. Now, since that time, a number of justices' papers with their docket books have opened up. When I started doing this, every justice burned their docket book at the end of every term, so you would never get them. Now some of them are in this building, and there are some more studies. But when I started this, I could see how did he vote in conference and how did he vote finally, and what systematically changed, who was able to get the votes in conference and pull them after conference, etc. So there's a lot of behind-the-scenes documentation and sources I got out of finding these amazing books.
And you get a sense of some of the stories about people shifting votes are really remarkable and just kind of illuminate the cases in a different way. Is there anything that kind of struck you in particular about an unexpected shifting in votes?
Well, the first thing to understand about the Taft Court, if you look at the modern court, you get a sense of how unanimous their opinions are. Between 30 and 40% of their opinions are unanimous. It's relatively unusual if you get a unanimous Supreme Court opinion. If you look at the Taft Court, the opinions are about 85% unanimous. This is a huge shift in opinion writing practices, the rise of dissent. And political scientists have been trying to explain why it is that around 1938, 1939, dissent rates began to go way up. So one of the things I discovered was the dissent rates weren't so different in conference. They were actually pretty similar, all things considered. Still slightly, I'm sure, smaller dissent rates back then than they would be in a conference now if I had access to a conference, but still, the opinions were about 35% unanimous in the conference. So what happens was that there was a norm that when a justice goes out of the conference, they have to acquiesce in the majority opinion. Every single justice in the 1920s felt that the judgment of the court was more important than what they had to say. This is not how justices now regard dissent. They regard dissent under the sign of the First Amendment. Justice Douglas, for example, probably the most prolific dissenter, the most profligate dissenter in the history of the court, says it's my First Amendment right to dissent. That would have been, Brandeis and Holmes would have found that incomprehensible as a way of imagining their role as a justice. Your role as a justice was to help form a court, to be bound by what the court did, not dissent. If you lost it, then you lost it. Then you're with the court the next time. So by looking at these docket books, I was able to show that the real question to ask is, why does this norm of acquiescence collapse in the 30s? And there's a lot of explanations in the book, but I was able to ask a much more precise question than the political scientists had been asking before.
I mean, that's really fascinating. I mean, it's fascinating because, again, we think of a certain level of dissent as the norm, and we wonder why was it so different in the 20s. And this shows that it's really the conventions of the court rather than the first reactions to the cases, which is, so it's a remarkable shift. So, and I want to focus in a minute on who's on the court and your analysis of their different approaches. But one of the things that I love about this book is it's a very different approach than other Holmes devised books. You know, other Holmes devised books are, you know, terrific analyses of the judicial decisions. And what you do is you situate them, and again, the analyses are terrific, but it's also in a historical context. You know, it's a story of a divided court confronting a nation in crisis. So let's talk about why is the nation in crisis? And again, as we're thinking about September 11th and thinking about our own time response to crisis, what's the crisis of the 1920s?
So, you know, you think about the 1920s, you think flappers, jazz, the boat beating against the waves to get to the green light, you know, the end of the Great Gatsby, that sort of thing. And it's, you know, it's a great fun time, but actually it's a time when the Ku Klux Klan in Indiana is like rising. It's the most people in the Ku Klux Klan in the history of the state. It's the time of immigration reform. It's the first time the U.S. closed its borders, the Immigration Act of 24 to foreigners. Immense prejudice, immense tension, high lynchings in the South. The system of segregation, of Jim Crow, gets consolidated and entrenched completely in the 1920s. So America is like very two-faced in the 1920s. And it's a country that's on the cusp of enormous change, but doesn't want to recognize it. So part of the reason why the Taft Court jurisprudence is so hard for us to remember is because it's so confused. This is a country that knew what it wanted, but didn't want to say what it wanted. It was filled with nostalgia. This is the time, you know, when Henry Ford is building his model villages as if you're at the founding. The Henry Ford who creates the assembly line is saying, oh, really, it's life back in the 1800s, 1700s. The country has just conducted World War I. So World War I is actually a fascinating global war. Very few people now have any memory of World War I. You know, it was Armistice Day, and then it became Veterans Day. You know, there's no monument to World War I in Washington, D.C. But at the time, World War I was one of the most massive eruptions and transformations in the history of the country. So take America, 1912. It's a country in which we're fighting Lochnerism, meaning we're fighting laissez-faire. Every time anyone tries to enact a reform, there's a lot of dispute about it because the government is best, which governs least. You have Herbert Spencer, et cetera, enacting Herbert Spencer. You have a country in which federalism is extremely fraught. Everyone thinks that the state should be running things. Every time the federal government steps in, it's a big deal. That's America, say, 1912. We have the progressive era, but still, even in the midst of the progressive era, there's this intense controversy of how much government do we want, how much federal government in particular do we want. And suddenly, along comes World War I. So the interesting thing about World War I is that it's a global war. And it's a global war against Germany. And Germany is winning the war, basically, because it's turned its economy into a war-making machine. And everyone realizes you cannot win the war unless you convert your economy from peacetime uses into the making and production of war materials, into tanks, into ammunition, you had to ration. Suddenly, the federal government steps in, and within 2 months, it nationalizes the railroads, it nationalizes the telegraph wires, it introduces a national labor policy, it sets the price of food, it sets the price of energy, it's complete price controls all over the country. You have Herbert Hoover leading the food thing, telling you can't use more than 2 cups of wheat when you bake a loaf of bread, et cetera, et cetera. Complete, total regulation of the economy, more than we've ever had before or since. It's like all of a sudden, out of nowhere, and it's the federal government doing this. So you had to do this. You can see in the newspapers, if we don't out-Prussianize the Prussian in turning our economy into an efficient war-making machine, we lose, because they'll beat us in the production of tanks, ammunition, army, whatever. And so we had to do that. Bernard Baruch creates the War Industry Board, totally converts all of the private industries into war-making industries. And this is in the middle of a country that's fighting about laissez-faire. Imagine the cognitive dissonance, and it happens all at once. Imagine, and we knew that it had to happen because we were watching the French and we were watching the British, and we were terrified of the Germans doing exactly this. So we knew we had to do it. We did it in a flash. Woodrow Wilson does it in a flash. Woodrow Wilson is the new freedom. He hates this. He wants to have laissez-faire. He wants to go back to the new freedom. And so the war ends, boom, November 11th, 1918. And as Leuchtenberg writes, Wilson was terrified of what he had made, and he ended it all, when Leuchtenberg's phrase, in a riot of reaction. It just stops the agencies. As a result of which, because you had price control, you put it up, there's inflation, the whole country goes bananas in 1918, 1919. But everyone is thinking, look what we can do constitutionally. It was a constitutional ban on forms of government regulation. But everyone suddenly understood you couldn't survive in the world of the 20th century, which was a dangerous place, unless you did this. So how do we reconcile that with our understanding of constitutionalism? They didn't do this under the war power. They did it under a regulatory power. And no one knew how to think about the problem, right? So you had a whole decade in which the potential of enormous government regulation had been revealed, and they were terrified of what had been revealed, and they didn't want to do it. And yet they wanted to do it, so they knew that the railroads couldn't function anymore. They create something called the Transportation Act of 1920, which for the first time intimately regulates all the railroads. They refused to nationalize it, but they put it under the intimate care. Intimate is the word that Taft used to describe the way the ICC regulates railroads. The intimate care, setting all the rates of all the railroads in the country and redistributing profits from profitable roads to non-profitable roads. And this is a country which is laissez-faire. How do they do that? They don't know how to do that. They created, during World War I, they created statisticians go into the government. We had no public statistics before. We didn't do that. Economists begin to run the country. Economists are the ones forms of economic knowledge to convert. How do you convert a car factory into a military factory? These economists were charting out the effects on so we have new forms of knowledge which make possible regulatory interventions which we now take for granted. These are all invented in 1917, 1918. They still exist in 1920. Certain departments of the federal government, like the Forestry Department, Department of Agriculture, Herbert Hoover's Commerce Department, continue to have this kind of statistical knowledge. And they continue to try to intervene in exactly the way that had been patterned by World War I. By the way, when FDR comes in and creates the New Deal, he just takes what Wilson had done, root and branch. Almost all of the institutions were just transposed in the 1930s. They come right out of this. So this survives, and yet the country's hell-bent to repudiate them. And the Taft Court's in the middle of this. Like, what do? What can and can't you do? They're making constitutional limitations. And it's an impossible situation. So that's one source of the crisis. We don't know how to survive as a modern country in the dangerous world of the 20th century. One crisis. Second crisis is, as a wartime measure, the country enacted prohibition. Now, remember, this is a country that thinks the federal government really shouldn't do much. Prohibition, suddenly the federal government has the obligation to regulate the drinking of every citizen, the intimate drinking of every citizen in the country. How the hell are they going to do that? They don't have the police force. They don't have the capacity, the institutional capacity to do that. They don't have the funding to do that. They don't have the they have no idea how to do it. but it's the form of symbolic politics that had become very familiar to us now. This is the beginning of that kind of symbolic politics. And it's created, by the way, which another innovation, it's created by the Anti-Saloon League, which was a conglomeration of evangelical churches in the Midwest and the South, led by someone named Wayne Wheeler, who was the single most effective politician in the history of the United States. He would make and break senators, make and break presidents, and he was a single issue lobbyist. It's like, I don't care what you're doing on anything else, but you have to be dry. And he would have block voting throughout the states, and he would make it so that prohibition really had very little to do with popular will and everything to do with a very strongly financed single issue lobby. So the country was divided over prohibition. But this division is so bitter and so deep that in 1920, for the one and only time in the history of the United States, Congress does not reapportion based on the census, right? They're supposed to take a census, they reapportion, They don't do it. Why? Because it would have given power to the wets in the cities, because people had moved to the cities, and the dries weren't going to permit that. Now, that is polarization of a very deep kind, because of course everyone understands you're always supposed to reapportion. That's the meaning of a democracy. No. And there was basically warfare in the streets between the wets and the dries. Overt law breaking by the most respectable citizens in the country. You all read, the Nobel laureate Sinclair Lewis, right? And he's got a famous novel, Babbitt. And in Babbitt, Babbitt is the leading citizen of Zenith. It's like an Indiana person. And he's got a dinner party, and he's inviting his guests in. He said, anyone want to break the law? And then he pours in martinis, like that. So this is huge. And the country is completely divided over prohibition. It's completely divided over what it wants to be. So if you ask why this powerful nostalgia takes over the 1920s, why it's the Ku Klux Klan rises and anti-immigration rises and anti-black sentiment in the South skyrockets, it's because we don't know what we are. We're caught in this nostalgia. Everyone is feeling threatened by these changes which they lived through 1917, 18, and they don't know what sense to make of them.
So the Supreme Court, this is a divided nation, a divided Supreme Court. Four approaches to the Constitution. What are they?
So here's the issue. If you have a country that's divided, how do you speak law? This is what I want to say to you that what finally allowed me to finish this book, working on it 35 years, what finally gave me the way into it was Trump. Because Harding appoints 4 justices in about 15 months to move the court to the right, to remember what Harding wants. He wants normalcy. He wants to go back. That's why I say nostalgia. He wants to go back to the days before World War I. He wants to go back. So Trump is appointing all these justices to move the court to the right. And second, the country now, red-blue, is pretty divided. So the court now has a problem, the modern court. Anything they say, you're going to say, oh, that's just your politics. That's not law. If Thomas opens his mouth, you're saying about Thomas, what do you mean law? That's just, you're a MAGA person. So a justice, when the country is polarized, has a problem. How do they establish the authority of law? And law is supposed to mediate between the red and the blue. Law has to mediate between the wets and the dries. Law has to mediate between the nostalgic Ku Klux Klan and the modernism of the Armory show in the 1920s, right? So law is that which is supposed to have authority for everyone, not just one side or another. That's the meaning of articulating law. So a Supreme Court in the middle of a polarized nation, which I saw starting in 2017, 2018 now, but it certainly was that way in the 20s. They had this challenge. How do you establish your own authority? And it's not just your political point of view. Remember, if we want to discredit a Supreme Court opinion, we say that's just politics and ropes. That's the attack since the 1930s. And the court was facing this. And so once you raise that as a problem, you see the strategies, and they knew it was a problem. They knew they had established their own bona fides. So you see, I saw 4 different strategies by justices on the court, all of which have more or less analogs now. So the one strategy, which was, I would say, the chief strategy, and it's entirely invisible to us now, would be the traditional American legal conservative. Law is the custom and traditions of the people, but not custom and tradition the way Alito talks about it in Dobbs. Those are facts. Custom and tradition, if you talk to a judge in 1920s, was normative. And this comes, it's interesting, you don't think of this very often, but this comes right out of Hegel. And the elite New York bar, James Coolidge Carter, would write these very influential pieces, coming right, having studied Hegel, saying law is the spontaneous self-ordering of society. If you asked an elite lawyer, and you see this in all the ABA presidential addresses in the 1890s and early 1900s, they contrast law and legislation. We think of what is law, we think legislation. They thought legislation, that just happens to be what a bunch of people gathering in a street corner happen to do on one day. The law is what the people really believed in their habits and customs, and it's the real beliefs, the real norms of the people, and it's the judge's job to perceive what those norms are, and then you could use that to check legislation, because legislation is just majority will. That's all it is. So the obligation of the judge was to be faithful to law. Law was custom and tradition, normatively understood, and that trumped legislation. Judges trumped legislators. That's the traditional American conservative outlook. James C. McReynolds had that in spades. He was like, he inhabited that world where he could tell you, what were the customs and traditions. And these were mere legislators. Why should we defer to them? They make a law, but if it contradicts what the people really want, and so it's a claim about what people really want that judges have some kind of access to. And and what that means, if you carry that through, is that the Supreme Court understood itself to be a common law court. That's what common law courts do. They say, what is the custom and tradition? What are the norms of the community? And the court speaks for that. And they didn't distinguish between constitutional law and common law. Each had the same authority. So when they interpret the 14th Amendment, they're interpreting it as a common law court did. It's almost impossible for a modern, after Erie, after modern positivism, to recapture that kind of judicial authority, but that's really the way they spoke. It's an amazing thing to see, to try to recover it. And the reason we can't is because at that very time, Oliver Wendell Holmes, the person who funded this project, is inventing what we call legal positivism. So legal positivism says, what are you talking about, customs and traditions? What are you talking about, society is organic and as a whole and spontaneously orders itself? This is the era when you have huge strikes. You have the Knights of Labor, you have Eugene Debs and the Debs injunction. The country is tearing itself to pieces. So Holmes, who comes out of the Civil War, sees society and he says, it's a myth to say that there are customs and traditions that a judge has access to that unite the people. Everything is contest out there. It's a Darwinian struggle for survival. And so the judge has no ground whatever to speak in the name of a common law judge, because there isn't a common law set of norms and customs to which any judge has access, because our society is full of conflict. So what is a judge to do? So he gives a very Darwinian account, which is his positivist account. He says, society will rip itself apart. It will actually have war. Remember, he comes out of the Civil War. He is always imagining that under the crust of civilization, violence is about to break out. That's Holmes. And he says, well, we've created law. We've created the orderly processes of change, which is law, meaning, when he says law, legislation, because law is the voice of the dominant sector of society. And the whole point of a legislature is it's responsive to the dominant sector of society. That's the key move that Holmes makes. And he says the legislature, not the judge, is the mouthpiece of the law, the mouthpiece of society. And so long as these contending forces have an orderly way of determining who's really dominant and saying who they can enact legislation, that's what should control judicial opinion making. So he inverts the conservative, and he creates the positivism, which every one of us now has. When Erie versus Tompkins, when we said there is no federal common law and diversity jurisdiction, that comes right out of Holmes, because judges do not have the authority to appeal to a customary. There is no brooding omnipresence in the sky, Holmes would say. Whereas a common law lawyer would say, what are you talking about? Cardozo would say, that's the community we're living in, and for Holmes, it's a brooding omnipresence in the sky. So the second way of thinking about this is Holmes's, where he says it's positivism, and we have to be loyal to the legislature, and we are, as he wanted to put on his tombstone, we are the supple tools of power, he said about judges, and the power is what the legislature does. So that's a second. A third, which surprised me, would be Taft himself, and people like George Sutherland, and in different moves, other of these justices, who said, what do the American people really want? What's really important to them that's deeper and more important to them than what their legislators happen to enact on any Sunday? They want to be rich. They want prosperity. They want economic growth. Remember, this is the 1920s. This is the bubble forming. And so it's not such an implausible thing to say that what everyone really wants, if we act in a way that's going to bust the bubble, that will really create social havoc. So the most important thing to do, that we can do, the thing that people will really agree on, is to protect the rights which keeps the bubble going. And what are those rights? Property rights. So these are people who, if you really think about that issue, that is saying that the economic sphere is prior to the political sphere. That's what we now call neoliberalism. The neoliberal approach is to say politics shouldn't interfere with the economics because we want the economics to maximize itself. That was Holmes. That was Taft, that was Sutherland. We have to keep the economics pure because otherwise things will collapse, and people will agree because they see the importance of the property rights and the prosperity they produce. So you get a whole jurisprudence of property rights, freedom of contract, etc. The interesting thing you should know is that the Taft Court revised Lochner. You might have heard of Lochner versus New York. This is where the court strikes down social and economic legislation. Lochner was viewed as more or less dead by 1912. The Taft Court revives it. The Taft Court becomes the great resuscitation of Lochner, and they strike down more statutes than had ever been done in the history of the court in the name of protecting prosperity. And finally, there's a fourth one, which becomes very important. But the striking thing to me, was shocking to me, is that it didn't exist before it was articulated in the 1920s by Justice Louis Brandeis. Louis Brandeis inverts neoliberalism. He says we're a democracy before we're an economy. And what people have in common is that they're democratic citizens, and they can pick whatever kind of economy they want. So the most fundamental thing we have in common is our ability to get together, to elect our government, and to live in a democracy. And we need to protect the rights of a democracy. No justice had said that before. If you look at Thayer, who says that courts should defer, he has no concept of democracy. He just says it's in Congress's power to read the Constitution. But he has no robust concept of what a democracy is, the kind of rights you would need for a democracy. So Brandeis invents that, and almost all of the rights that we have in the Warren Court are coming out of Brandeis. John Ely is coming right out of Brandeis. The Caroline Products footnote 4 is coming right out of Brandeis. He is imagining us as a democracy, and no other justice had done that. So if you ask, is something unconstitutional in 1922? Most justices on the court would say, well, what's the constitutional right? Is it a property right, freedom of contract? We ask. Does it violate freedom of contract or not? End of story. Right? We look at the constitutional right. Brandeis says no. In such a situation, there's always two constitutional values at issue. The one is the democracy that enacted the statute. So if you strike down the statute, you are denying the people their right to be democratic and to govern themselves. That itself is a constitutional value, and that value has to be balanced against whatever other right is at stake, freedom of contract. So it's always a balancing. That view of the thing didn't exist before Brandeis, and he's putting that forward, and he is, not Holmes, not anyone else, no one on the court is putting that forward. And we do not get a court even begin, or justices begin to appreciate that until the 1930s. That was a stunning discovery of mine.
So one of the other, I mean, there's so much about this book that I loved. One of it is that you recover these four approaches. So I think for most of us, the New Deal is about the struggle against the four horsemen, who are the bad guys. And what you do is, I mean, it's a little bit like the musical Wicked. You tell the story from the vantage point of the Wicked Witch of the West. These people who are always the bad guys are actually, subtle and important thinkers. So the Taft view and the McReynolds view.
Well, you can see why the prosperity view collapses in the 30s, because they're saying, we're protecting your property rights in the middle of the Depression. The rest of them are going to say, what are you talking about?
But, again, it runs through. The four horsemen are, part of your story, right? So let's take a concrete example. So prohibition. So how does the court divide when it confronts prohibition?
So this is such an interesting history. So think about prohibition. This is the government saying to you, you can't drink. And this is, urban workmen saying, I can't what? Oh, what do you mean I can't drink? I'm going to drink. I'm going to go to the saloons. I'm going to, So you have the court, you have a constitutional amendment which is attempting to override the customs and traditions of the people. So this is like a law school exam, It's not merely a statute trying to override customs and traditions. It's the constitutional amendment. And in the end, as someone said, that I quote, the woman who was in charge of Women Against Prohibition, she says, they thought to make prohibition as strong as the Constitution. What they ended up doing is making the Constitution as weak as prohibition, which is telling you something about, I write in an area called popular constitutionalism. The law has, and even a constitutional amendment can only have the authority that we give it. And you can see that very clearly in prohibition, where people were saying, this is a constitutional amendment. And they would say, I don't care, I'm going to drink. And you get a lot of people saying, like Wayne Wheeler saying, well, I mean, if you don't obey the constitutional amendment, everything will fall apart because you have to obey law or the country dissolves. And Clarence Darrow is debating Wayne Wheeler in Chicago, and he says to him, yeah, when did you last go south and tell people about enforcing the 14th and 15th Amendments? When did you do that? And everyone at that time understood that the 15th Amendment and the 14th Amendment were dead letters, and they were just saying, oh, well, the customs of the South are so strong, we can't enforce it in the South. But we can't enforce 18th Amendment in New York City and in Chicago, and people in New York City say, no, you go enforce the 14th and 15th Amendment in Alabama, then we'll talk about prohibition. And this raised huge issues about transferring judges, southern judges north, northern judges south, because the norms were so completely different in different parts of the country over this very issue. So if you think about this jurisprudentially, it raises the question of, should the positive law of prohibition, which was completely bone dry, override the customs and traditions of the people? Now, I've told you there are at least two different narratives that raises. One is a positivist narrative, right? Positivism associated with home puts legislation over customs and traditions. In the end, what we now call the administrative state depends upon Holmesian positivism. It depends on the ability of government institutions to create law which have nothing to do with your customs and traditions because they want to make clean lakes or they want to have clean air, whatever it is. That all comes out of Holmesian positivism. But no one is accepting Holmesian positivism in the 1920s. But prohibition is a perfect example of it. And you have these people like McReynolds who are saying, no, I mean, it can't be law unless the people embrace it spontaneously. And no one is embracing prohibition except if you live in Alabama or, Oklahoma. So what are we talking? If you look at, by the way, the dry states and the red and the wet states, it's blue and red. I mean, 100%. So what you see is that the conservatives on the court split over prohibition. Half of them, Taft And Sanford and Vandervander turn Holmesian positivists. They become the most positivist judges because they think that the whole legal system is at stake if people could just sort of defy prohibition. If you think about what is the precursor of the New Deal, it's prohibition. It's the ability, it's the court. Taft leads a very dry court, but he leaves it 5-4. The court is really doesn't, many justices don't like this, but the Taft wing associated with Holmes and Brandeis say the people have willed it and therefore we enforce it, positivism. This is the administrative state in the 30s, and it's prepared by the conservative justices like Taft and Vandervander in the 1920s. It's a really interesting thing. You can see them enforcing administrative regulations that have many analogies to New Deal administrative agencies out of this very thing. And there are 3 conservative justices, McReynolds and Butler and Sutherland, who peel off and say custom is more important here. And so they oppose prohibition. And I can show statistically that the conservative bloc, which is together when they're trying to strike down social and economic regulations, splits over this question of prohibition. And precisely the split is one side thinks they preserve the legitimacy of law, including the legitimacy of the 18th Amendment, by ameliorating its tension with customs and traditions, whereas the other bloc says, no, we have to be positivist about that.
What about Brandeis and Holmes? Where do they fit in on this?
Well, Holmes, this is easy for Holmes. Holmes is saying, this is what positive law is. If they want to go to hell in a handbasket, that's my job to let them do it. So Holmes has no problem with prohibition. He's like as strict as they come, even though he's, serving liquor in his house as people send him liquor, and he writes his correspondence. He says, may they lead us into temptation. He writes people when he gets these bottles. Brandeis is much more subtle about this because, remember, Brandeis isn't at root a positivist. Brandeis is at root a Democrat. So what does a Democrat have to do? On the one hand, the Democrat says they enacted this 18th Amendment. This 18th Amendment was ratified more quickly than any other amendment in the history of the Constitution. Boom. It just, because it was World War I, it just went right through. It's like no one understood how quickly this was ratified. And the nation woke up one day and said, oh my God. So they've done it. There's also a law, the Volstead Act, which interprets the 18th Amendment to mean bone dry, no liquor at all, 0.05% alcohol. So I have to defer to democracy. But on the other hand, you watch Brandeis learning over the course of the decade that if the administrative state, the positive law of the administrative state through a democracy is too at odds with what people actually believe and their customs and their traditions, the state itself loses legitimacy, which is what happens in prohibition. The state becomes a joke. The police forces become a joke. The prohibition department is corrupt. No one trusts the state because of it. It's undermining the ability of the state to do things you want the state to do. And so progressives like Brandeis begin to split on the issue of prohibition. And they split precisely because they begin to understand that customs and traditions define legitimacy. And if the state is too much departs from them, overrides them to too great an extent, we can't use the government to do what we want the government to do, which is to intervene in constructive ways. And so it's like a horseshoe. He sort of comes around and he sort of now gives a progressive idea of custom and tradition. This doesn't, by the way, revive itself. Do you remember Griswold versus Connecticut? In which, say, Harlan's opinion, Goldberg's opinion are that the reason why the state can't regulate birth control is that we have these norms of privacy which have to be respected. So here are social norms overriding positive law. And so the liberal Brandeis begins to see that, and the classic expression of that is his dissent in Olmsted. Olmsted is a prohibition case. This is a wiretapping of a bootlegger. And he makes the claim that you can't enforce wiretapping like this because the meaning of the Fourth Amendment is privacy. And privacy is norms of the very kind that he himself had written about in the 1890s in his famous article on the right to privacy, a common law right. He's reading common law rights social norms and conventions back into the Constitution through the Fourth Amendment in order to rehabilitate the dignity of government in a democratic way. He argues that that's different than the conservatives in terms of the norms, but the structure's the same. And so that impetus of a liberal communitarianism, call it that, dies when prohibition is repealed, doesn't revive until the 60s. And conversely, the conservative positivism of Taft, where he says we just have to enforce the law, that dies when prohibition is repealed. And it comes back, do you remember who was the most, it comes back with William Rehnquist and Justice Scalia, who are conservative positivists. Before that, positivism has always been a liberal idea. It was always associated with legislature could override and judges can't get in the way. And that was the progressive position. It becomes a conservative position only with William Rehnquist and Scalia, who are getting it from the Taft prohibition opinions.
So you got 4 takes on the Constitution. How do they line up? You talked a little bit about that, but how do they line up with where the court is now? I have to think about this, but there is a big movement. This is my view, so take it with whatever grain of salt. And I'm not speaking here with the authority of an historian. I'm speaking here as my understanding of what the court's doing as a legal person, as a legal scholar. But I'm no expert in this. But I think what you see in originalism, and what you see in its second cousin textualism, and what you see in its third cousin history and tradition, these are all variants of Holmesian positivism. They're all variants of ways of saying, we, the judge, we don't have any agency. The law is decided by facts. And an originalist judge will say it's by the fact of the original public meaning. A history and tradition judge, like Alito in Dobbs, will say it is the facts of the history and tradition of whether the states permitted or didn't permit abortion in 1868. There are other forms of that. Will Bode has written like that, and the same Amy Coney Barrett kind of is close to that, or Bruin and Thomas in history and tradition is kind of close to that. You see in a recent First Amendment case, Vidal, the court going. So this is all Holmesian. And I've just actually written a piece on, it's not actually in the book. I don't do, my specialty is First Amendment law, but there's no First Amendment stuff in this book because I was too sick of writing about First Amendment. But I just wrote up of a case that comes out in 1925 called Gitlow. It's one of the most famous cases. And it's a case in which Benjamin Gitlow is put into Sing Sing for 10 years for advocating violent revolution. So it's an abstract advocacy. He's just saying basically it's a good thing if the proletariat, if we have a dictatorship of a proletariat. And it comes during 1919, and there's this Red Scare, and the New York puts him in jail, and the Supreme Court affirms that, says you go to jail. The First Amendment doesn't protect this, but it's not technically the First Amendment because it's New York, right? And the First Amendment applies only to Congress. So Gitlow is the first case to interpret the liberty interests that are protected by the 14th Amendment and that do apply to the states to include freedom of speech. They don't think of it as incorporation the way that we do. They weren't saying it's the First Amendment through the 14th. They were saying, what does liberty protect for freedom of speech? And to my shock, I'm going back, and Holmes writes a very famous dissent in this, clear and present danger, which is a First Amendment test joined by Brandeis. So I'm going through the history of this, and you have to understand that Holmes and Brandeis they hated the liberty interests in the 14th Amendment because this is what was funding the court's ability to strike down social and economic legislation. The very liberty interests that Gitlow was appealing to, the court uses to strike down, say, laws which saying you can't discriminate against union members, or laws which say an employment broker can't charge a fee to a worker. And these are the very cases that the ACLU is citing to the Supreme Court to say that the liberty interest should include freedom of speech. And so it's very ironic that you have a dissent by Holmes and Brandeis, which is saying, one,
that liberty, it should be expanded in the 14th Amendment to include freedom of speech, and 2, it should be strictly interpreted and the burden should be on the state, clear and present danger. How does that happen? And so I'm tracing Holmes's opinion. Holmes is the person who says you should not read your own views into statutes. You should take the words of the statute, and that's it. And that's why he's saying you shouldn't use the 14th Amendment liberty of contract. That's not in the 14th Amendment. You're putting it there. You're putting in Herbert Spencer, and it shouldn't be there. And yet he's now putting in freedom of speech. How is that possible? And the answer is Holmes's theory of why law, any law, has legitimacy is, as I mentioned to you, positivism. And positivism says that legislation has legitimacy as law because it reflects the dominant view in a society. And on Holmes's account, what is sovereign is the dominant view in a society, the dominant faction in a society. That's what sovereign was. The sovereign is he who had the power. It's very Hobbesian. But then how do you know that the legislature is representing the dominant view? And this is what Holmes came to realize in November 1919 in his Abrams dissent, and very clearly in 1925 in his Gitlow dissent. You can't know that unless you have freedom of speech. It's freedom of speech which aligns the power in the legislature with the social forces of who's dominant and who's not, because they fight it out in the realm of public opinion. Holmes has this argument about the marketplace of ideas and truth, and everyone always says Holmes is about you can't know what's true unless truth is what's accepted in the marketplace of ideas. That's a really silly idea. I mean, Holmes could not have believed that. And you want to see it silly. If you want to know, do the COVID vaccination make you glow in the dark? You wouldn't go on the internet and see what's popular on the internet. You wouldn't look at the marketplace of ideas. If you want to know whether there's climate change, the last place you would look at is influencers on TikTok or what's popular. Popular opinion and what's popular is not any measure of truth at all. And Holmes knew this, so he was speaking metaphorically. What he really meant in Abrams' dissent, and what he's very explicit about in the Gitlow dissent, is we need freedom of speech so that the legislature can perform their role of being responsive to the dominant views in society, and therefore legislation can be authoritative. That's what he means. So notice what he just did. He read the liberty interests. This is the man who invents positivism in the United States. He's the most rigorous analytic practitioner of positivism in the history of the American judiciary, and he just read the Liberty Clause of the 14th Amendment in Gitlow in a purposive way, not a positivist way. He said, what are the values? And I'm going to read it in light of those values, because my own positivism, the very ability to depend upon facts, presupposes that what the legislature does is valid. So the argument of this piece is that purposivism of this kind always underlies positivism of the kind you see in the modern court. So the modern court says, oh, all of those states banned abortion in 1868. So what? Tell me why that's how you read it. You need a theory of the clause before that kind of positivism in the court now makes sense. And I can point to 1925, the inventor of positivism, Holmes, in this work, as seeing it exactly that way.
I think one of the things that's very striking is when you talk about, as they're grappling, particularly Brandeis and Holmes, with a range of difficult circumstances, there's movement in their jurisprudence, right? So you talked about kind of an embrace of purposivism by Holmes. When you talk about, Olmsted, it's Brandeis embracing kind of custom in a way that he never had before. So, it's very striking that these are kind of people grappling with difficult issues, and it's not just about the politics. It's about trying to think these things through. Is that right?
Totally. I mean, to me, if you study the court, if you're studying a court of serious people, footnote, if you're studying a court of serious people, and these were serious people, this was a president of the United States, these were senators, these were attorney generals, these were people of considerable public importance in the United States who had positions of great importance, and they're serious, then you want to see what they're trying to do. Law is a form of action. It's not a given. It's not a rule book. If someone tells you, I don't know who would ever say such a silly thing, but if they were to say law is just umpires calling balls and strikes, it's obviously not that. It's people trying to make sense of their role in a given context. And if they're serious about it, they're going to grow, they're going to learn, they're going to see things that they didn't see before, and their jurisprudence is going to develop. And so this is really a book that I mean to be about the work of doing that. And I don't have to agree with them, but I can watch them working to be serious from whatever their perspective is. And it's an amazing thing to watch. It gives you great humility, actually. Me.
Yeah, I mean, it really is. It's fascinating, exactly what you said. Serious people grappling with difficult issues, really discussing with each other. I mean, when you look at the docket books, they move. And, it's, I have to say, I found it inspiring to look at that. So we have time for a few questions, but what's the legacy for you? What can we learn from the Taft Court? My final question before I open it up to the audience. What can we learn from the Taft Court?
Well, I think one thing we can learn from the Taft Court is to do the job of a Supreme Court justice, you have to be serious. You have to really care to get it right. And you have to have the courage of your convictions to do it right. And it's easy to if you're just voting your politics, you're not serious. You're just not serious. None of those people voted their politics. And they had very violent politics, but none of them voted their politics. They were all trying to get it right by their lights. And that's the way the court is going to earn respect, if people believe that. But then they have to really believe that.
And it's very, one of the things that's very moving for me in reading it is you develop a great affection for these people. And at the end, when Taft dies, it's very sad. So we have time. How much time do we have for questions from the audience? 20 minutes? Okay. Questions from the audience? Jonathan?
Hi, thank you for this brilliant talk and brilliant book. I wanted to pick up where you left off, but also go back to the beginning about how the level of unanimity was so much higher then, and ask you to say or speculate a little bit more about really what lay behind that, in the sense that you've laid out these four dramatically different approaches to the law and to judging. So, right, you had these colleagues who had very, very different views of how to resolve these cases. So going along was not a simple thing, right? You were going along with somebody whose basic legal philosophy could be radically different than your own. And yet, it sounds like across the board, there was some kind of shared understanding despite those other differences. Can you elaborate on that a little bit? And one sub-part of the question, as it were, I think you mentioned that it sounded like one group of cases in which there might have been more division were the prohibition cases. You mentioned 5-4. Maybe there was more division in those. If there was a subset of cases in which the court didn't come together in the same way, maybe that offers some clue about why that was unusual.
So let me just start off with the way in which political scientists have typically done this. They've said, oh, it's the invention of legal realism. And before that, they would just all saw things the same way. And I can show that's not true in the conference. They say that it was the Judiciary Act of 1925. One thing I haven't talked about is Taft's immense architectural influence on the federal judiciary. And so Taft is a former president, and he comes into the court as Chief Justice, and he completely reshapes Article 3. I mean, mind-bogglingly so. So the first thing he does is creates the Judicial Conference, and he creates the idea that judges should be transferred to district courts which are behind in their docket. So we have a national constituency, and there's a whole branch which is together as a branch designed to meet the docket problems of Article 3 of the federal government. So in other words, he's imagining the judges as a branch of government. This had never happened before. Before, it's every district judge in their own, paddling his own canoe, as Taft would say, in his own district. And there was no relationship between them. And he suddenly unifies them in the judicial conference with the Chief Justice supervising through the council of the Chief Circuit judges, and he unifies that. He also changes the nature of the Supreme Court in many ways. One is he builds the Supreme Court building, which is huge and a really interesting story, but I'll bracket that. He lobbies Congress to get through and causes the court to draft the Judiciary Act of 1925. This is the court writing its own jurisdiction statute. It wrote its own statute. Taft, Taft is meeting with the president every other week, so he gets Coolidge to lobby Congress to pass it. He's meeting every week with the chair of the Senate and the House Judiciary Committees. He's lobbying this person and that person to get it through. He lobbies it through. Now, the Judiciary Act of 1925 allows the Supreme Court of the United States, for the first time really in its history, to select its own docket. It was before that a final appellate tribunal. Most of its cases came up by way of mandatory jurisdiction. I have a right, you said, to carry my case all the way to the Supreme Court. So the Supreme Court was the final vindicator of all federal rights. So it's a final appellate tribunal. It has huge numbers of cases, and most of them are trivial because they come up as a matter of right through either a writ of error or appeals, which are mandatory jurisdiction. They had some certiorari jurisdiction, which is invented in 1891 in the Everts Act, but for the most part, the forms of way, the opinion writing practices and the voting practices of the court are formed within the context of a final appellate tribunal, like a court of appeals now. They have to decide every court that comes. And the way in which you're going to vote and write opinions in such a court is totally different than the way in which you would write it in a court after Taft's revision of the Judiciary Act of 1925, which is to say, I'm only going to pick the cases which are not important to the litigants, but to the country. Before that, the cases are important to the litigants. There's huge numbers of them. And the court's just a very different kind of place. So John Hesson Clark is on the court when Taft gets there, and he resigns within 9 months, and he writes Woodrow Wilson, and he's a liberal. So this is one way that Harding gets to consolidate the right wing. He resigns, and he writes his friend Woodrow Wilson, who had appointed him. He's saying, you can't imagine the trash that I have to decide. He says, most of these cases are trifling. They're trivial. It's just a complete waste of everybody's time that I'm up there. I mean, he writes it as like fully description of what it was like to be there. You're deciding crap. It's like a court of appeals case, judge now. And he said, I don't want to do that anymore. It's very funny, and when you retire, you write a letter to the court. So Taft says, can you write us a letter? And he writes a letter saying, I am so happy to be out of that dump. He says, where I have to, be deciding all these terrible cases. And Taft writes him back, I don't think you realize we're going to publish this in the U.S. report. But that's the work environment. And what are the practices in that environment? One, the opinions are written for the litigants. What's a dissent going to do for a litigant? Two, the idea of law comes out of the dispute. This is a court whose primary function is dispute settlement. So when you do dispute settlement functions, typically you imagine law as pre-existing. You imagine it as stable. What the court does is more important than what you're saying, because you've got to settle the dispute. This has what I call in the book the authority of finality. The best expression of that was Jackson. He says, we're not final because we're infallible. We're infallible because we're final. So the court was infallible because it was final. It was the finality, the dispute settlement. So dissent had very little role if you were deciding it for all time. Law was decided, and it was static. And it was directed toward the litigants. The Judiciary Act of 1925 changes all of that. Suddenly, the court is selecting cases, very explicit. I don't care about the phrases that the justices use in lobbying. Who cares about the mere litigants? The mere litigants. We're doing it because these cases are of national importance. We're laying down rules, says Vincent much later, for the general public, he says. So he says to lawyers in front of his bar, Chief Justice Vincent, he said, every one of you, whether you know it or not, or have a class action, you're really speaking for people who are not before the court. So all of a sudden, the audience is changing. The nature of the law is changing. Because if I'm a member of the general public, I don't have to accept the judgment of a court. If I'm a litigant, I do. If I'm a member of the general public and you're talking to me, why do I have to accept what you said? Remember Lincoln about Dred Scott. If I have to accept what Tawney says, then they run the country. I don't accept that. An opinion is not binding. A judgment is binding.
But do the numbers shift after 1825?
Does what?
Do the numbers shift after 1925?
They shift in 1938, 39, as they begin to internalize what it means. And you can show, and what collapses is the norm of acquiescence. I feel like it's more important that what the court says is more important than what I have to say. That's the key move. And this, as it begins to be internalized about whom they're speaking to or what sort of law they're making, this all starts to change. But it takes a while to sink in. It's a profound change.
Dan?
Just following up on a related issue, what did you find about Taft's performance in internal management of the court, of the other justices and relationships between the justices, and his own authority over the other justices?
Well, first of all, he was a president. Mr. President, so he just carried enormous weight in the internal councils. Brandeis says to Frankfurter, he says, they'll take it from Taft, but they won't take it from anybody else, he says. And it's true. I mean, the guy was the real thing. And they all viewed him as the real thing. He was a great manager. Henry Stimson, who served with presidents from Teddy Roosevelt to Truman, said that of all the presidents he ever served with, Taft was the best administrator. Taft was a superb administrator. He invented the federal budget, for example. He invents that. He fights with Congress that you should have budgetary control. He's just very ordered. He was a terrible politician, which is why he was an awful president as a president. Samuel Gompers once described him as a very large body surrounded by politicians. He had no capacity. He wanted to be an administrator, not a politician. And so when he went on the court, everyone viewed him as a terrific administrator. They all loved him as a Chief Justice. Part of the problem was he starts having strokes in 1924. He has a terrible one in 1926, and it goes to his brain. He gets arteriosclerosis, so it gets harder and harder for him to concentrate. And so at the beginning, he's a very independent-minded judge. He makes his own. He dissents. What's called the masterpiece of the Taft Court is a case called Adkins, where really shockingly, they strike down the minimum wage law for the District of Columbia because the court, you could count 5 justices before then who would find this constitutional, and suddenly it reverses itself. It's the Sutherland opinion. Taft dissents in that. He dissents against, Brandeis is recused because his daughter is running the minimum wage agency, but Taft dissents in a really good opinion. He writes with Holmes. So he's independent, but when his brain starts to occlude because of these, and I have all of the medical records, it's really interesting. He's treated with, he has a kind of fibrillation. He's treated with quinine. I gave his medical records. He has one of the first EKGs, it's like 1920s. I gave it to my doctor, and he read it, and he said, he has this kind of fibrillation. And he was treated at the time with a quinine compound, which now we don't give because it increases the probability of strokes. This is exactly what he suffered from. So he began to get more vague, more diffuse, and more dependent upon the people who become the Four Horsemen, on McReynolds and Butler and Vandevanner. And so he begins to lose control by, say, 1927, 1928. And you can see it in the quality of his opinions.
And they also have a tremendous affection for him, personal affection.
He's an honorable man, you know, I would say. I mean, I disagree with him on like tons of things, but the man is honorable. And the older I get, the more I prize that. The rarer it seems to me.
Other questions? Jess?
What can you say about the personal conduct of the justices of the Taft Court? There's been a lot of scrutiny of the conduct of our current justices. Some of them have very wealthy benefactors. Others have had spousal connections to political controversies. Was it similar then? Were they very closely engaged in the political process, or did they have patrons? I mean, what were they like in that sense?
They were hugely engaged in the political process. In fact, I have chapters. Taft's view of the Chief Justice was closer to that of an English Lord Chancellor than to any American judge. So he was a weekly newspaper columnist when he gets put on the court. And he says, I have to stop my column because I'm supposed to be separate from politics. And then he starts speaking about law reform. And he gets criticized on the floor of the Senate. The Senate says, you should shut up. You're a justice now. What do you mean telling us what to enact? And Taft says, no. He says, I am going to continue talking about what I know about. And even though this could come before him, the constitutionality of the reforms, he continues to do that. And he's actually in dialogue. In fact, I have a letter from, it's not the AP, but it's some news organization who writes Taft, who says, has there been some official change in the norms where justices now feel free to talk about public controversy? And it's in Taft's correspondence is a no answer, he says all the time. But he does these things which we would now consider to be quite unethical. So Taft, like many of the justices of his time, like Holmes, was very anti-jury. He thought juries were terrible. They were swayed by plaintiffs' lawyers who would, wave the bloody shirt of the injured workman. He hated juries. He loved to have trial courts have control, and he thought that state courts, which had given power to juries and taken away the power to summarize evidence and to instruct juries in the state by state judges, that had destroyed the efficacy of justice, many kinds of justice in state courts. So he's really anti. So there's a senator named Carraway who puts out a bill in the Senate Judiciary Committee, 1924, and in this bill he says federal judges shall no longer have the power to instruct juries and to summarize the evidence. And the Senate enacts it. And then it goes to the House, and the House Judiciary Committee approves it. And then Taft learns of it, and he goes hysterical. I mean, he is just like, they're going to destroy the federal courts. He says to his wife, I'm going into action, Nellie. And he writes a memo, which he shows only to the president, to the Attorney General, Harlan Stone, and to the Speaker of the House, and to Vander. And this is a 20-page memo saying this is unconstitutional. So it's a private, constitutional opinion about an issue that would come before him. And through lobbying through his manuscript, he gets it killed in committee in the House, and it keeps coming forward. But he did that. And I can show lots of times when he's making these constitutional arguments, and they're all making constitutional arguments to members of the House and Senate about pending bills. So there was something different about the way they imagined their relationship that is on this one he knew he was bad because he only showed it to 4 people, right? So you can see he knew there was something bad about it. He writes letters to his enemy, John Walsh, who is later to become FDR's Attorney General, but dies of a heart attack before being confirmed. But he was like Taft's nemesis in the Senate. And he would write, but he was chair of the Senate Judiciary Committee, and he would write letters saying, oh, this bill that you have before you, it's a really good bill. It's totally constitutional for these reasons. This is his enemy he's writing this to. And they would all be doing things like that. So there's a big difference in the underlying norms. As to personal venality, I didn't see any evidence of that really at all, anywhere.
Okay, I think we have time for one question. Professor Peter Byrne.
Hi, Peter.
Hi, Robert. It's so fascinating. When I heard you were working on the Taft Court, I thought, wow, what a waste of talent. But Robert, I just shows how ignorant I was and how interesting you've made it. So the other great constitutional amendment at the beginning of the 20s was the 19th Amendment. And I wonder what you saw about if there was no federal establishment, but the different thoughts that the involvement of women and sort of the beginnings of women liberation showed up in the court's work.
Well, there is an opinion by Brandeis. There's a challenge to the 19th Amendment, as there had been to the 18th Amendment, that they were unconstitutional amendments. And Brandeis writes the opinion saying it's a constitutional amendment. But this is before my period. This is before Taft. And the only time it actually comes up during my period is in this Adkins case. This is a minimum wage law for women. And Sutherland, who was, by the way, one of the major proponents of the 19th Amendment, Sutherland was a big advocate for it. He was very close to Alice Paul and to the Women's Party. And he says the 19th Amendment says that this can't be constitutional. Now, I've always thought that was a complete non sequitur, and Holmes famously says in dissent, it will take a lot more than the 19th Amendment to convince me that women shouldn't, receive the benefit of a minimum wage. There's a lot of literature in the history of feminism about the division between, say, Florence Kelley, who wants protective legislation, and Alice Paul, who's against protective legislation. And she actually files a brief in this saying you should strike it down because it's protective legislation. So in my view, nothing about the case is really turning on the fact that it's women. And you know that because 2 years later, there's an opinion which Sutherland writes on a case called Radici, which would prevent women from working during dark hours in bars in various cities. And he upholds it on the classic protective rationale. 19th Amendment never enters his consciousness, doesn't go anywhere. So, they appeal to it, but it's really, if you look at the logical structure of the thing, irrelevant, and you can see that it's actually irrelevant because they go ahead and they approve protective legislation without even a second thought.
Very good. Well, thank you. I think we're at the hour. Round of applause. Amazing book. Great conversation. Thank you so much. That was fabulous.
It's fun.
That was a lot of fun.
This is a really tough act to follow, but I'm Jean Dennis. I'm with the Congressional Research Service, and I am going to be talking about the Constitution annotated online for a few minutes. First, though, I want to thank the Law Library for hosting this amazing program. I learned a lot of history today. So, let's see if my slides are working. The Constitution annotated, for those of you who are not aware of it, has been Congress's official record of the Constitution for almost over 100 years. And it provides an explanation of every provision of the Constitution. It's handy. The Constitution annotated has a very long history. It was the outgrowth of a project that Congress began in 1797 when it first passed legislation to provide for a copy of the Constitution to be printed and given to every member. By the 1830s, they had started to add indexes to these constitutions, and then by the 1870s, they were including lists of Supreme Court decisions for each provision. As you can well imagine, by 1921, those lists were so lengthy that Congress passed additional legislation to provide for a Constitution that was annotated with an explanation of every provision. Our beloved Constitution annotated. We had a change in this iteration of the Constitution in 2019, and at that point, the library decided that we would move it from its paper version. We just published the 2022 version, so if you want a paper version, you can get it, but it's 2,700 pages, and Representative Bice used it as a weight at one point for exercise purposes. So here, and some of you might have had picked up a pocket Constitution. That pocket Constitution, if you look at the QR codes, will take you to whatever the relevant section is on the website. So anyway, in 2019, we launched the Constitution Annotated online, and it is the web version of the Constitution Annotated, the book that's been around for over 100 years. Since its launch, constitution.congress.gov has had more than 33 million visits, and more than 63 million page views. So this version, this digital version, is considerably more popular than our 3,000-page PDF that we had prior to 2019. The Constitution Annotated is written by the lawyers from the Congressional Research Service, and it complies with CRS's standards of being authoritative, objective, timely, nonpartisan. So, a little bit of background on how to use the Constitution Annotated. There are two primary ways that people can find information. And the Constitution Annotated is designed to make it very easy to find information on the Constitution. The first way that probably a lot of people who have law degrees might use is our search function. We have a search bar on every single page of the Constitution Annotated, and people can do keyword searches. So here we have a search for the exclusionary rule, and we have an image of results that came up if you were to do it. If we go and click on the link, we get to an essay. And what we saw on the previous page, there's actually 11 essays on exclusionary principle, exclusionary rule. And the search term will be highlighted. And we have a footnote. For every footnote, we try to incorporate the Supreme Court decision so people can click on the link and go directly, and they can read the underlying primary source document. And part of this is because we are objective, authoritative, and nonpartisan. It's our analysis has to be completely transparent so that we're not adding anything of ourselves. We're looking at what the Supreme Court has said about these issues, and if you went to an appellate court and you expected them to apply whatever the Supreme Court precedents, it would be very easy. At the top, you can see a row of breadcrumbs. Those show you exactly where the essay is located with respect to the Constitution's structure. Oops, what happened? There we go, sorry. The other way that we have, the other primary way for finding information in the Constitution Annotated, is through our Browse feature. And one thing about the Constitution Annotated is that it's actually written for a non-lawyer, non-lawyer-trained audience. It's designed for members of Congress who may or may not have a law degree, and also we expect the general public to be able to use it. So if you're not trained in the law, you may want to start just browsing the Constitution for looking at what you might be interested. Here, we're going to be looking for something on the bicameral Congress. Whoops, I keep hitting the wrong thing. There we go. You can search, scroll through the outline of the Constitution. You can click on the legislative branch if you want to know about a bicameral Congress, and then just scroll down until you find something that is relevant. And here we click back, and we have origin of a bicameral Congress. This is the exact same essay that you might have found on a keyword search. And we also have additional constitutional materials people can get. We have reports that are written by the attorneys at the CRS that deal with constitutional topics. And we also have a number of links to the library's amazing resources on the Constitution. They have one of the best collections in the world on the Constitution. One thing that is very exciting, and I don't think people might have put the math together when I started speaking, but this is actually the 5-year anniversary of the Constitution Annotated Online, and we are kicking it off with a podcast series, which is going to be starting on Constitution Day. This is going to be a monthly podcast, and it is going to be sort of directed for a non-lawyer audience. It features a unique documentary style so that people can actually listen to clippings of the Supreme Court justices discussing aspects of the cases when they are in oral argument or later. And it is once more authoritative, objective, and nonpartisan. So we are very excited about our podcast series, and it will be on the library's podcast platforms, as well as on Apple and other places you might want to get podcasts from. And then the other big development we had this year is our new evolving jurisprudence for the Supreme Court. This is a new section we added, which basically goes over what are the constitutional cases that are now pending before the Supreme Court, provides a short synopsis so somebody can find and get up to date very quickly on what the Supreme Court is thinking about and what constitutional topics may be of particular interest. And of course, it is updated when those decisions come down contemporaneously. So we try to have everything updated on the Constitution annotated on the same day that the Supreme Court comes out with their opinions. And finally, just to wrap it all up, the Law Library is our public face. So thank you, Aslihan and Robert. And so if people are looking and they need any assistance with it, this is the contact information for the Law Library. So thank you all very much, and please have a wonderful Constitution Day.